Lord, I beg to mention item number 3.
Yeah.
Lordship, Mr. S. Bhattakur appears in this matter for the petition and he has gone to vote in his hometown, my lord. Can it kindly be taken up on any other day?
2 weeks. 2 weeks.
Much obliged.
My lords, I beg to mention item number 27 of today's list, my lords.
27.
27.
Yeah.
My lord, this matter may not be taken up today, my lord. Some personal inconvenience on the part of the conducting council, my lord. I've already informed the other sides.
Adjourn.
Deeply obliged.
Well, I beg to mention item number 7 of the to-do list, my lord.
Item number
7,
7.
yes, my lord.
Yeah.
In this matter, some development is going on, so my lord, come it on the after 2 weeks, my lord. Okay. May I please, Lord. Proceed with respect to item number 17. May I please this matter be taken on next Tuesday or Wednesday, Lord? Please,
After a week.
much of it.
May I please, I beg to mention item number 29 and 30, my lord.
29 and 30.
30.
Yeah.
My lord, in item number 29, appellant has filed one affidavit. I want to file rejoinder to that effect, my lord. So I pray that this matter may come on.
Adjourn.
All right.
Right, please, Lordship. Lordship, I beg to mention item number 23 with the concern of other side.
23.
Yeah. Lordship, conducting council is out of station, Lordship. Matter may be adjourned for a day.
Adjourn. Yes.
Wait, please, your lordship. The urgency in this matter is that I'm a tutor in upper primary school and I'm living without payment for more than 1 year. So matter will be listed urgently.
Next week. Any date in the next.
Much obliged.
May I please, but I beg to mention a matter for motion. Auction sale is on 24th, Lord. On Monday, Lord.
Tuesday. or Wednesday.
Deep Lord.
Yes.
For orders, item 1.
Well, an appeal by the state. The debate is for condemnation of delay, my lord. The objections have not yet been filed to the. Otherwise, my lord, from the date of the order of the writ petition, there is a delay of 1186 days. While from the date of the review order, my lord, the delay is of 210 days.
Is also very significant.
Well, it is significant, but my lord, the order which has been, which is assailed, my lord, there's a division bench order of this honorable court, which says that the order of the learned single judge and other similar orders are, my lord, per se illegal. Because they,
Division bench.
by the division bench, there is an order, my lord. And in fact, my lord, the learned single judge was a party to that division bench, my lord, which passed that order, my lord. Yet the review was dismissed. If lordship would have the impugned order. Where, my lord, we were required to exercise our exercise that order, my lord, that starts at page 116. The review of the
116 of the IA.
of the appeal, my lord. Sorry, my lord. The IA, my lord, the IA, my lord, the impugned order has not been perhaps accepted. Was filed much prior in there. So 116, my lord, relevant portion would be at 126. These teachers had not completed 2 years of service.
This is the review petition.
This is the review order, madam.
Where is the original order?
Original order, lordship will find. That is a page. Page 100 and it's page 69 onwards, madam.
69.
59 onwards. The relevant portion lordship would find at page 92. Para 41, my lord.
It's 5th of April 2013.
My lord?
This the order is 5th of April 2013.
Yes, madam. It was 110. Seventy-two. Lady one 92.
Order of the learned single judge for consideration of the cases of the petitioners,
My lord,
their the writ petitioners for their provincialization
my lord.
on the basis of the earlier decision of Jibon.
Chandra Dekha, my lord. In Jibon Chandra Dekha, what had happened, my lord, there was a concession by the state where we had said, where it was made, there was a submission made that we will relax the 2 years period and we will go ahead to do it. A list was given to the state. All those people were considered. But thereafter, we said there could be no further concession because of the rules, which say that, my lord, a minimum of 2 years period is required. Now, if lordship would kindly have the orders passed by the division bench at page 110, my lord. In similar matter, same circumstances, my lord. Otherwise, I have the printed copies also. We have annexed it to the appeal. The learned single judge's order in that case is at page 105. Division bench order is at page 110.
This order is dated.
My lord, this order is dated 26/2014, my lord. At the top at page 110, we have given. The date of the order is at the top. After disposal of the review in the present case.
So all these persons have not completed 2 years of service.
They did not complete 2 years of service as on the date of the coming into force of the act. Therefore, this honorable division bench in this particular case has held that there can be no relaxation, there can be nothing. If they do not fulfill the rules, nothing doing. So this case will be covered by that judgment.
Order.
Right now, it's legal and it would like to get the light of
Ultimately, the direction is only for
My
consideration.
lord, the direction is also to invoke the power of relaxation to grant them the relief. That is where the difficulty is, my lord. Because in Jibon Chandra Dekha, we had, if lordship would have page 111, my lord, the division bench held that there can be no parity, no relaxation can be given. The relaxation part is the difficulty.
Yes, what do you want to say?
Lord, with regard to delay, my lord, I have not received the copy of appeal memo, but delay, my lord, the review was dismissed on 39/2015. And my lord, thereafter, there is about 1 year, 4 months delay, my lord. But there is no,
Then something days, no? In review, after filing of the review, the appeal was filed after how many days?
My lord,
After about-
review was disposed of on 39/2015, and we filed the appeal on 4/5/2016, a delay of 210 days, my lord.
210 days, not a year,
my lord,
not a year.
but 39/2015 review dismissed, then my lord, about a year, my lord.
4/5/16 we filed it.
No, sorry, my lord, that is not a year, less than a year.
Ultimately, we have to consider that the division bench has expressed otherwise.
My lord, there are two judgments, my lord, with regard to the earlier judgment, that is of Badshah PR, my lord, that judgment is already considered in the review petition, my lord.
Which
The-
one?
The Badshah PR judgment, my lord. And
The division bench judgment.
There
Which
are
he has
two
referred to
Division bench judgment came after the review petition, my
after
lord.
the review.
After the review petition.
that judgment I have not gone through.
Look here. The matter comes up for consideration of the IA number so and so. The player for conducting the delay of 1,000.
186 days.
1,186 days in filing the connected appeal. Then it concept of the applicant has submitted that the learned single judge, while judgment dated 5/4/2023 in SB is WPC number
6842 of 2010.
just a minute.
3 representations with
Triple 6666 oblique 2010 and another connected writ petitions, including WPC number 6842 oblique 2012 has issued a direction to the respondents to the state to consider the case of the writ petitioners for provincialization by invoking power of Rule 7 of rules by the state government at par with 130 dropped teacher in whose cases provision of Rule 5 bracket में 3 was relaxed. It is contended that a review petition is filed on behalf of the state before the learned single judge, which came to be dismissed by order dated 30th of September 2015 on the ground that if the plea of the review petitioners is considered at this stage, that would amount to re-hearing the writ petition, which is not the scope and object of the review jurisdiction. So, it is contended that after dismissal of the review petition, the connected appeal is preferred with a delay of around 210
days.
days. Full stop. It is contended that the division bench of this court in similar matter division bench of this court in
VTP number 228 of 2014.
where is that order?
That order also you will find at page 109.
109.
The VTP number 228 of 2014.
In writ appeal number 228/2014 decided on
26 2014.
26
26 2014.
20th of June 2014
Hello.
has clearly held that an incumbent who has not completed 2 years of service is not entitled for provincialization. And the case of the writ petitioners is squarely covered by the said observation. Learned concept of the applicant as per the submitted that the delay in filing the appeal is occurred due to administrative reasons, and the applicant has no intention to file the appeal with delay. Learned counsel appearing for the non-applicants has opposed the application for condonation of delay and has submitted that the state has failed to explain the day-to-day delay in filing the connected appeal, and therefore the delay is not liable to be condoned. Stop. Heard the net consent for the parties. It's true that the connected appeal is filed with a great delay of 1186 days. However, it cannot be ignored that the division bench has ruled otherwise in a writ petition, in a writ appeal
22.
related to a similarly situated employee. And in such circumstances, we deem it appropriate to dispose of the connected appeal on merits. Hence, the delay of 1186 days delay in filing the connected appeal is liable to be condoned. The IA number so and so is allowed, the delay of so and so days is condoned. registry is directed to register the connected appeal and list it for admission after 2 weeks.
I'm obliged.
In the meantime, the counsel for the state may supply the copy of the writ appeal to the counsel for the respondents, who may file his response by the next date of hearing.
Obliged.
Item 2.
In the IA, my lord, we have filed the IA, my lord, 37 of 2021. And the last order, lordship passed an direction to the petitioner to file an affidavit on that, my lord. And we have filed the IA, my lord, Annex 1, my lord, page 11, my lord.
Have you filed the affidavit?
In that IA, they have not filed the affidavit, my lord, that in the name of the Chief Justice, my lord, notice was published in the newspaper, my lord. So the Honorable Court directed the petitioner to take the curative measures and file an, at least, my lord, unconditional apology, my lord, to lapses on his part, my lord. That affidavit has not yet been filed, my lord.
We sought apology in the affidavit which we filed before this honorable court, your lordship. And lordship, at the same time, my senior Mr. K.N. Chaudhary, today he is not present in this case. Lordship, I may pray that matter, since the pleading is completed in the present case, matter may be taken up on as an admission hearing and as an
But
initiative to
with
final.
respect for this IA. What,
Should we file the
petition is for what?
My lord, IA, my lord, we are bringing,
What relief they are seeking in this petition?
that they are seeking, my lord, that regarding the acquisition of land for national highway, my lord. I am appearing on behalf of the Tala, my lord. Land acquisition has already been completed. Land has already been allotted in the name of the Union of India, my lord. Road has also almost completed, my lord. And they,
large scale embezzlement. API. IA is on block. IA, this IA will file with the principal secretary of Kala.
But what you are saying, the IA, what you are seeking? What
we are
relief you
bringing
are
to the notice of the Honorable Court, my lord, Annexure 1, page 11, my lord.
Annexure 1,
1
page
page 11,
11.
IA, my lord.
IA.
My lord. That is the summon was issued, my lord, despite our appearance, my lord. Name of the Chief Justice was printed in the, my lord, newspapers, name of the judges, and asking the, my lord, principal secretary to appear before the court, my lord. Though, my lord, standing counsel appears on behalf of the, my lord, principal secretary, my lord. So we are bringing notice of the court, my lord.
Without there being any order from the court.
My lord.
Okay, such a thing.
So, my lord, the Honorable Court passed an order, my lord, directing them to file an affidavit in that particular IA, my lord. That has not yet been filed.
Lordship, I may be given a single opportunity so that I can rectify the same mistake, your lordship.
Court has granted them
Lordship,
on
a single
11/11/2020. Desirable substitute be published in the local widely. It is stated the Hill Times are widely according to the petition steps of publication of aforesaid to release in consecutive days. And pursuant to that, they have got this notice issued in the.
It is our mistake, your lordship. We have to go through the registry, but
Mistake, it's not a simple mistake.
lordship, we sought sincere apology at the same time, a single opportunity so that we can rectify it, your lordship.
Substitute service.
Still not filed any affidavit.
In that IA, my lord.
Lordship, in the main writ petition, main PIL,
I mean, this
we sought
IA,
apology, your lordship, in the affidavit.
where
which
is
we
that?
It is on record, your lordship, the affidavit
Record?
in reply.
PIL.
PIA.
What is the date of the affidavit?
You have not filed any affidavit.
In the highest end of
No, Lordship, it's not in the. Lordship, a single
Where is the
opportunity.
question of apology there?
Lordship, in the affidavit in reply which we filed on in the month of September, Your Lordship, 2023, in paragraph 3, we sought an apology for the direct paper publication, which is
For
made.
direct paper publication, that
We have to go through the registry of the.
Seek apology for direct paper publication, which is made by him. What do you mean by, there is no question of this apology. You were supposed to get the notice published, but not in the name of the honorable judges. Where is the explanation for that?
Lordship, we presented, Lordship, that is why, Lordship, I am seeking a single opportunity, Lordship. I should make the clarification and file a fresh reply, Your Lordship. Fresh reply to that IA, Lordship.
Publish in that same newspaper. It was only done here for the guy. No, you have to first publish in those newspapers that it was your mistake.
Lordship,
This is a wrong publication and
Lordship,
it stands withdrawn. That you first do.
Lordship. I'll do.
After that, the question of, and second thing is, where is the statement in your PIL that the affected persons are unable to approach the court? So you are taking up their cause. The people who have been deprived of compensation, ordinarily they have the remedy to approach the court.
Lordship,
There
here,
is a statement that they can't approach the court for XYZ reason.
Lordship, in the present PIL, we have pointed out the measures which is adopted with the incorrect measures which is adopted by the
Whatever it
KAC.
may be. But you have to convince, this court that the persons on behalf of whom you are approaching are not able to approach the court.
Lordship, allow me some time, and on the next day, Lordship, I shall satisfy with this honorable court on this point also. At the same time, I shall take corrective measures, Your Lordship, for the mistakes which is taken up earlier, Your Lordship.
Okay. This court, while order dated 11/11/2020, was permitted the petitioner to get the notices issued to the unserved respondent through paper publication. Pursuant to that, a notice was published in the daily newspaper, which is that daily.
Ireland Daily.
Two newspapers, is it? You published in two newspapers.
Ireland Daily. That is the newspaper.
Ireland Daily and the Hill Times
Hill Times, my lord.
on 14/12/2020, wherein the name of the honorable judges who has passed the order dated 11/11/2020 has been mentioned to stop the respondent. Your respondent number, the counsel for the respondent has
8.
brought this fact into the notice of this court
527.
by filing the present IA. The contention that no summon was issued to the respondent number 510 to appear on 17/12/2020. Despite that, a newspaper notice was published in the above referred to daily newspapers on 14/12/2020, 4/12/2020. Stop. In the last occasion, then it counsel for the petitioner raised some time to take corrective steps. However, no affidavit in relation to the corrective steps taken has been filed. Instead, an affidavit is filed on behalf of the petitioner wherein it is simply mentioned that the petitioner seeks to seek apology for the direct paper publication. We are not satisfied with the explanation given by the petitioner. Counsel for the petitioner raise further opportunity to take effective corrective steps and to seek apology for his conduct. Time paid for is granted. List after 2 weeks.
Deeply obliged, Your Lordship.
Item number 4.
May it please your lordship. In the month of October last year, your lordship, direction was issued to us.
13/10/2023.
Yes, we have not been able to comply with your lordship's order.
Why?
We have not failed to establish contact with the client, your lordship. If your lordship can proceed.
Dismiss the petition for non-prosecution if you have no contact with the client.
I apologize for that, your lordship. That would require some instructions. In fact, if
No
on,
contact with the client, then certainly you have no instructions.
in fact, we
We'll
prepared
dismiss the petition.
the applications for removal of respondent number 5's name, but that has not been done, as your lordship.
Whatever
fact-
it may be, if you are saying that you are not in contact with your client, then certainly it's a case of no instructions.
Maybe one last opportunity can be granted and subject to what your lordship determines. Your lordship,
How
on
much cost?
my oral instructions, if your lordship can,
How much cost for one more opportunity?
that will again, your lordship,
For that you will take the instructions
and
from whom, which is not in your contact.
yes, your lordship. That is an unfortunate situation here, your lordship. I'm just asking for one accommodation, your lordship, in this regard. In fact, if on my verbal submissions, your lordship can delete respondent number 5, I'll be grateful for that. Otherwise, your lordship, I'll seek instructions and I'll
Once the
advise the
order
court.
is passed, you do it.
Yes, your lordship. There was ample time given to us, your lordship, and we had also proceeded to prepare our application for that. But we could not proceed further on that regard, your lordship.
Retired. Your client is already retired,
Yes,
long back.
not long back, your lordship, in the month of February. This was
What is the effective relief you are seeking?
that is also, in fact, your lordship,
It's an instruction repetition.
the issue, your
The
lordship,
respondents have also retired, almost all of them.
the issue which has been raised, your lordship, subject to what your lordship determines, is her seniority to have been fixed in the gradation list. Seniority in the grade 1, your lordship, which was
So
published.
even though if we fix the seniority,
Yes.
what benefit you will get
The
out
matter
of
might be academic, your lordship. There might not be any fruitful
That-
result here, but
what remains?
one last opportunity to apprise this court, your lordship. I'll not make an unfair submission before this court, your lordship. If one last opportunity can be granted to us to agitate, if at all there is any cause that the client may want to proceed further. Just one occasion, your lordship. I'll not pay further beyond that, your lordship. A short date, your lordship will fix as per your lordship's convenience.
On 13/10/2023, this court granted counsel for the petitioner to rectify the cause title. However, till date, need to till date, the same as not the direction given by this court has not been carried out. Full stop. And it counsel appearing for the petitioner has submitted that he failed to make contact with the petitioner. However, seeks one last opportunity to complete his instructions. Whether any cause of action survives or not. Full stop. Last opportunity of 4 weeks is granted, list after 4 weeks.
I'm grateful, Your Lordship.
Granted time work.
Item 5.
May I please, Lordship? If the office note indicates that steps not been taken,
Yes.
but if I have taken steps today morning, Lordship.
The morning to office note is not incorrect.
Lordship, yes, it is not incorrect.
I mean, concept of the applicant has submitted the steps. Has already been, the necessary steps have already been taken for service of notice upon the respondent. Full stop. Registry to check, and if the steps are taken, let notice be.
Much.
Returnable 6 weeks.
Item 6.
Service take 70% so can 50%, 40%. FCA is coming at it. If you can notice, then legally concept that. Legally concept
That is lordship. My lord,
Anybody is appearing for the respondent?
my lord, we have taken the steps on those three services. There is office note on 17th of February, my lord.
Yeah, that has been be completed on the whole respondent.
The appeal is admitted, lordship may post it for hearing, my lord. In the meantime, if it comes, my lord.
Mr. Agrawal was directed to appeal as legal aid counsel.
But there is an order to this
Withdrew
effect.
her instructions. Okay.
Withdraw. He did not respond, my lord.
Despite service of notice upon the respondent number 5, none is appearing. None is appeared on behalf of him. Let the writ petition is already, the writ appeal is already admitted, listed for final hearing after 6 weeks.
Lord.
Sold it. Hold the sold it. Appeal may sold it.
Sold it.
Retail puts for this 16 by 10.
Hearing in due course. On 6 weeks.
Item 8.
If there is a mistake on my part, Lordship, I made a wrong submission that Mr. Mazumdar is appearing for a private respondent. That may be corrected, Lordship. I may be allowed to take fresh steps through the local police station, Lordship, and as well as register post. We took a steps in the last September, Lordship, but service report has not come back.
There is a perjury proceeding initiated against your client.
Lordship,
Legal.
Lordship. That explanation is also I have because that was a previous of 2010 punishment that has been referred to. At that time, the Army Act was applicable because
No, but Learned Single Judge has observed that your client has made a false statement on affidavit.
that I have explained.
You are not seeking review of that
To
observation.
that regard also, Lordship.
Okay. So, on the last occasion, on 5/2/2024, this court has directed. This court has issued a direction to the registry to reflect the name of Mr. R. Majumdar, advocate, as counsel for the sole respondent, but it appears that Mr. Majumdar is not appearing on behalf of the sole respondent. In such circumstances, we deem it appropriate to issue notice to the respondent number,
Sole respondent.
sole respondent. The requisites be filed within a period of.
Lordship, by register post as well as through the local police station, Lordship.
Local police stations, what do you mean?
Because during the condemnation stage, he was evading the notice, Lordship.
During the,
Condemnation stage. Earlier, matter was pending for condemnation, Lordship. That was delay has been condoned, Lordship.
the delay has been confirmed, then why? through the
Now
police-
now notice has been issued in the writ appeal. Already
Appeal,
notice.
that's right, but why through police station?
Why police station?
Why police station?
Because he is evading, Lordship. The other, the register post,
Evading, what do you mean by evading? That there are many other means.
Lordship.
Can ask for, if he is evading deliberately, you can ask for further publication. Why through the police station?
Okay.
Registered AD. Returnable for this.
Item 9.
This is an application for condonation. There is a delay of 23 days. The respondents have been served.
Yes,
But I have no objection. 23 days.
the IA comes upon for consideration of the. This IA is prepared on behalf of the appellant with the prayer to condone the delay of 23 days in filing the present connected appeal. Then the counsel appearing for the respondent has no objection if the delay is condoned. Having heard the learned counsel of the parties and after going through the contents of the IA, we deem it appropriate to condone the delay of 23 days in filing the connected appeal. Hence, the IA is allowed. Delay of 23 days is condoned. Office is directed to register the connected appeal and list it for admission after 3 weeks. After 3 weeks. You are in receipt of the copies of the appeal?
No.
Will serve.
A copy of the appeal be served upon the respective counsel for the respondents who may file their counter by the next date of hearing, list after 3 weeks.
Who is for 10, respond number 3?
Respondent number 3 also has been served. We have filed, we have taken the C and we have filed an affidavit.
Lordship, I have.
Yeah, 3 and 10 in Dasti ka order. 10 he has appeared, he has not appeared.
We may, yeah.
Yes, sir.
You are for 3?
Yes, sir. I'm appearing for he's in official capacity, my lord, I'm appearing.
Then
Item 10.
The notices were issued. Respondent number 5. Let notice be issued to the respondent number 5 only. Anybody is appearing on behalf of the respondent number 5? Await return of notice of respondent number 5 for 3 more weeks.
Item 11 and 12.
Lordship's notices were issued on the last occasion, and I'm
Services
told my
complete.
learned friend is appearing today.
Yes, you are appearing for the sole respondent.
Yes, my lord, in both the writ petitions.
The appeal, writ petition. Okay.
This is against the order passed by the learned tribunal, my lord. They have raised an issue of jurisdiction. Learned tribunal has held that tribunal has got the jurisdiction, my lord.
That is the first writ petition before your lordship.
Okay. Mr. So-and-so put in evidence on behalf of the sole respondent in both the writ appeal. Services therefore complete.
Writ
Writ petition, my lord.
Writ petition services therefore complete. This is writ petition for admission. Well,
My lord, any short date because the entire proceeding of the tribunal has been stayed, my lord,
stayed by whom?
by this honorable court, my lord.
Mr. So-and-so. 14th of May.
Lordship.
Fine, my lord.
Deeply obliged.
Item 13.
Lordship, item number 13, may I please your lordship? Lordship, conducting council has informed me she is out of station due to her casting vote today. So please kindly pass over the matter for lordship.
Was the typographical mistake? Office memorandum, there is the correct. 1998. 1988. But she will not be conflict. This IA is preferred on behalf of the petitioner or the appellant or on behalf of the petitioner in the prayer to correct the typographical error
In the order dated.
in the impugned order dated 23/2/2024 passed by this honorable court in connected writ petition, that is WPC number 6896/2023. It is contended that there is a mention about one office memorandum dated 1/9/1998, whereas the correct date of the office memorandum is 1/9/88. Having heard the learned counsel for that, having gone through the application filed on behalf of the appellant, on behalf of the applicant, we deem it appropriate to allow the same. And it is ordered that the date of the office memorandum, wide number 152/79/80 79-80/KVS/budget/part second dated 1/9/1998 be read as memorandum number so and so dated 1/9/98 in the order dated 1988 in the order dated 23/2024 passed in writ appeal or writ petition number 6896/2023 writ petition number 23. The IA is disposed of.
Item 14.
Yes, that's just to justice. Council casting both.
Yeah, 17 days.
I file objection.
How to file objection?
Right.
Substantial objection or just for the sake of objection?
I have a strong objection.
Strong objection. Then we have to give time. Mr. So and so, appearing on behalf of the respondents, seeks respondent number, respondent number 1. Seeks, we have to issue notices to the other respondents also.
To the other respondent, the headmaster of the school,
Issue notice.
opposite party number 2.
Mr. So and so put in appearance on behalf of the respondent number 1. Let notices be issued to the respondent number 2. Returnable on so and so. In the meantime, the respondent number 1 we file objection to the IA number so and so.
Obligation.
Item 15.
Please, your lordship, this is an application for condemnation of delay of 265 days in filing the writ appeal.
What's the reason for delay?
Well, the reason is, my lord, both the representation which was directed to be considered by this honorable court, the single judge of this honorable court, as well as the order of the honorable single judge of this honorable court was communicated to the governing body in Calcutta, my lord. Calcutta, the school is in Balipara, Assam, my lord. They did not receive the copy, my lord. That is the reason.
Issue notice of the application. IA number so and so, returnable on so and so.
Deeply obliged.
16,
Yes. What corrections you are seeking?
the name of respondent number 2 is required to be struck down.
Deleted, and what about the respondent number 1?
In respondent number 1, represented the earlier representative was the respondent number 2. That is required to be changed.
So many complaints. Why you are not you filed a amended writ petition? You are seeking so many corrections in the order.
My lord, I will file if your honor permit. Your honor permit.
Because this kind of application cannot be allowed like that. इसके जगह उसको डाल दो, उसको होता है तो we filed an application so you need to amend it. Permission दे नहीं उसको लिखना पड़ेगा ना क्या है You want to criticize you payment. You payment. You need to take it. What? Taking into consideration changes is we limit appropriate. This IA is filed on behalf of the applicants with a prayer to allow them to make certain corrections in the body of the writ petition.
Yes,
In the body of the writ petition. After taking note of the fact that the petitioner is seeking various corrections in the body of the writ petition, we deem it appropriate to direct the petitioner to file amended writ petition instead of seeking correction in the body of the writ petition. Changing the cost. All right, yeah. The chief secretary then number 6. क्या चेंज कर टेक्निकली ये आपका ये Seeking correction in the present, seeking correction in the body of the writ petition. The IA is disposed of. The concept of the petitioner is at liberty to file a amended writ petition within 2 weeks within 2 weeks by making necessary correction in the original writ petition.
I sense this.
Item 18.
The interim judgment is at page 209. And it should not have been dismissed on the first day because Learned Miller Junior, he sought time. And it is dismissed on the basis of the Dilip Talukdar's case. Dilip Talukdar case has a window, your lordship knows, for bringing them for encadrement. So we can pray for encadrement. And second, my lord, about 85 persons, my lord, who were appointed in personalized posts, my lord, they were promoted. So on that ground, my lord, 2 writ petitions, my lord, are pending before this court. Dilip Talukdar's case is very clear, my lord. It says, my lord, if you are appointed in personal post, you are not entitled to be promoted.
Here also you are appointed on the personal post.
Yes, yes, on the personal post, but there is a window, my lord. There is a window. Oh, there is a window. It says, my lord, I can pray for encadrement.
Notice returnable on 2020.
My lord.
Registered AD.
And only prayer, my lord, prayer, my lord, to file a representation for encadrement. That they can consider, that the division bench, that para 12.
Let the mother party may come, they'll dispose it of.
Yes. That we have. All right.
नहीं. Which one? Which? 16. Here is this put. Here already. Here.
Item 19.
Similar is already.
Lordship has memo appeal has to start. Yes, yes, I'll sub the memo of appeal.
Then concept of the state has submitted that. Identical appeals have already been admitted in this court. Full stop. Taking into consideration the fact that identical appeals have already been admitted by this court, we deem it appropriate to admit this petition to admit learned counsel for the Mr. So-and-so is appearing on behalf of the sole respondent. Service is therefore complete. Copy of the memo of appeal be supplied to counsel for the respondent during the course of the day. This appeal, writ appeal along with writ appeal number 50/2024 for hearing in due course.
Item 20.
Maybe Lordship. My senior is on leg, Lordship. Matter may pass over for the time being.
You argue the matter. The time of your appointment as president of the SDMC, you have already crossed the age of 65 years.
Yes, Lordship. But that was not for the fault of myself, Lordship, because the
Yes,
authority
you
has
made an application for in the year 2021, and ultimately the order was passed in 2023. But the fact remains that you have crossed the age of 65 years on that day. How can you continue?
Lordship, I have not prepared the case. Lord.
Pass over for the time.
21.
And
The impugn order was passed by the honorable single judge. Not on merit, but for delay in approaching in this honorable court. At page 15,
About 13 opinion, you are thinking now the delay is not there.
delay,
Yes, delay there.
delay has occurred, my lord,
Delay vitiates everything
because I'm fourth grade employee, my lord.
without any explanation. What else?
This is the not on merit,
Merit when there is once the delay
but
is
they have
there,
admitted my,
until and unless you pass that hurdle, why the court should entertain? It's the stale claim. The appointment is of the year 2012, 13. If you approach the
2014, my lord.
13, 14 and you approach the court in 2019, what else?
Because not non-approval of SIU, because of not granting SIU approval, my lord.
Say it.
I could not be appointed. Hmm?
Now it's almost 10 years have passed. What to leave now? How can we direct them to give appointment?
It is. My lord, one
Ultimately,
thing is,
even if you are selected, that is not an indefeasible right for getting appointment.
I could not be appointed by because of not fault of mine, my lord. But after written examination, they approached the.
Then you should have approached the court in time.
That is it.
What do you mean? Okay. I think this writ appeal is filed by the appellant being agreed with the order dated 14/6/2023 passed by the learned single judge in WPC number 6723/2019, whereby the writ petition filed by the petitioner has been appellant has been dismissed only on the ground of delay. Full stop. The case of the appellant was that before the learned single judge was that he was selected by the School Management and Development Authority for appointment to grade 4 post of Roka Kata HS School Dugri. However, on account of some litigation pending in the court, the appointment order could not be issued. In relation to the selection took place in the year 2013-14, the petitioner has approached this court in the year 2019 by way of filing. The appellant has approached this court by way of filing writ petition number 6732/2019 with the prayer to issue a direction to the respondents to appoint him on the post for which he was selected. Full stop. The learned single judge, taking note of the fact that the appellant has approached this court after a lapse of 5 years without any explanation, and therefore has dismissed the writ petition on this sole ground by impugned order. Full stop. When we consider the appellant has submitted that instead of dismissing the writ petition on the ground of delay, then a single judge should have decided the writ petition on merits. Full stop. Having heard the learned concept of the appellant and after going through the impugned order as well as the material available on record, we don't find any illegality. We don't find any case for interference as the petition, as the appellant has approached this court after an unexplained delay of 5 years. Full stop. Is also to be taken note of that the selections took place in the in the years 2013 and 14, and now after lapse of 5 years, after lapse of 10 years, no direction for appointment on the post for which the applicant was selected can be issued. Hence, we don't find any merit in this appeal. The writ appeal, the same is therefore dismissed.
Item 22.
Met with yourself. An improved order is page 61, my lord, of the single judge, my lord. Whereby, because of the petition was dismissed.
Yes.
Basically, we filed a writ petition on by challenging selection of the respondent 3 and 4, my lord, on 2 grounds, my lord. First of all, they have granted marks of under the head of experience in additional qualification, but respondents number 3 does not have any experience and additional qualification, my lord. And second point was, my lord, that UGC regulation was not followed in selection procedure, my lord. But what was held that, my lord? Can you look at the page 63, para number 4, my lord? Para number 4 of the judgment, my lord. 63 page number.
Yes.
Mr. So-and-so, Lawrence Counsel for the petitioner argues flowing grounds. Additional marks have been granted to the respondent number 3 against experience and educational qualification, which the respondent number 3 is otherwise not entitled, for which the petition is deprived from the selection, and therefore selection process is vitiated. And second, my lord, even if assumes that selection committee has rightly granted marks, however, selection committee by the APSC was not even constituted in terms of extant norms and rules. Selection procedure prescribed under UGC Act so and so and under UGC regulation so and so, my lord, ought to have been adhered to. Such regulation prescribed a selection committee consisting of 3 subject experts for selection assistant professor in government colleges. However, in the case in hand, such rules had not been followed by the APSC, my lord. The mandate regulation 2010 for selection cannot be avoided, citing the prescription procedure mandate in APSC rules 2010. A harmonious reading is required to be done between the mandate of the APSC rules. In support of such contention, Mr. So-and-so relied on decision of this court reported in 2015 3-11. Now, my lord, kindly come to the page number 15, page number 68, para 15, my lord. Coming to the second part of the argument, that is award of marks, etc. This court has perused the record produced by the learned counsel.
Just if the regulation is silent as regards the prescription of procedure of the selection process, and if they have adopted this 2010 this rules, what's wrong in that?
But there is in rule 2010 rules, my lord. The selection for a post of lecturer of government, all government college, my lords. In government college institutions, and the UGC rules have to be followed, my lord.
So far as regarding appointment of teachers in the medical and the Ayurvedic college, no prescription is there.
But that rules is in respect of all government college, my lords. And that government Ayurvedic college is also availing the benefits of UGC scheme, my lord. And also getting the pay scale, my lord.
Notice. Register AD. You are appearing for
It is your lordship, respondent number 2.
only
And you have four?
one issue notice, Mr. Sultan put in appearance on behalf of respondent number 1 and 2. Let notice be issued to the remaining respondents, returnable registered AD.
Item 24.
Please, your lordship. My lord, this matter relates to settlement of fishery, my lord. And here we have challenged the order of the honorable single judge, which is at page 41 to 46, my lord.
Which for the other side? For the private respondents?
Private respondent, we have taken steps 4 times, my lord, by registered AD as well as Dasti, my lord. And the private respondent refused to accept the Dasti, and that we have filed affidavit. So,
Who is running the fishery now?
my lord,
Your client is running.
he is not running because there is an order of the honorable single judge, my lord. So,
But there is a stay order also.
You are aware of that stay order?
my lord, I have filed one IA for stay, my lord. Stay of the, my lord, order of the honorable single judge, my lord.
In the meantime, Dr. B.K. Sharma, Learned Senior Advocate Assam shall apply regarding this fresh settlement of
The stay.
What happened?
My lord,
Concerning the fresh steps you have already taken?
no, my lord, because of pendency of the though there is no interim order, my lord, as per instruction I have received, my lord. As per the earlier settlement order, my lord, the private respondent is running my lord, appellant is running the fishery, my lord.
Appellant is running at
Fine.
present, but she is saying that she sought a stay for that.
No,
My
Madam, who
lord,
is running the fishery now?
my lord, actually, the appellant is not been allowed to fish in the fishery because of the tendency of this matter, my lord.
But you are already running.
Yes, the order is in our favor, my lord. The order of the, my lord.
initial order, which was under challenge in the writ petition, my lord.
But that order is quashed and now who is running the fishery?
My lord, petitioner is not running because he is not allowed to fish in the fishery, my lord, because of this.
My lord, written instruction I have received, my lord. Although, my lord, that order has been set aside and us, my lord, because of pendency of this writ appeal, my lord, no fresh NIT has been issued. And accordingly, they are running the fishery.
This is written instructions.
And then, my lord,
Then what?
I don't have, my lord, I could not contact the petitioner recently. So that is-
You have said that. Why you have made this statement that nobody
This
is-
statement was earlier the petitioner has informed me, my lord.
For the respondent has, the respondent state has submitted that as per his, as per the written instructions received by him. At present, the fishery in question is running by the appellant only. The counsel for the appellant seeks some time to complete her instructions. This up to 4 weeks.
25.
This is Somoto, my lord, PIL. And in forest and Assam, my lord, there are 23 division, my lord, without any working plan, my lord, they are running.
4 division in respect of the London Advocate General informed this court regarding.
The latest position is that out of the 33 forest divisions in Assam, total forest divisions, working plans are required in 32 because in the Majuli division, there are no reserve forests. So out of those 32 forest divisions, in 10 of them, there are approved working plans in place. In three of them, Your Lordship, Dhemaji, Lakhimpur and Gwalpara, the working plan has been prepared and placed before the State Consultative Committee on 27th of March, Your Lordship. Some changes have been recommended. We are working on the changes. In respect of 6 divisions in BTC, Your Lordship, the working plans again have been, preliminary working plans have been prepared, Your Lordship, and they have been placed again before the same State Consultative Committee on 27th, Your Lordship. And some changes have again been recommended. We are working on them. And in the rest, Your Lordship, that is 7, 10, the data collection process is underway.
Amongst the 23 forest division in Assam, working plans for 10 of the forest division has already been approved and implemented.
I have prepared a small chart, Your Lordship. Perhaps this will clarify.
In respect of 4 forest division, the matter is pending approval of state government.
Total, my lord, 32 forest division, my lord. Out of 32, my lord, 31 is required.
No,
because
of
32 is required.
By what time you'll get these necessary approvals and what?
Your Lordship, the process is that first, after the collection of data is over, a preliminary working plan is prepared. That preliminary working plan is placed before the State Consultative Committee. After the changes are recommended and then they are implemented, the final working plan is prepared. That is again placed before the State Consultative Committee. And once it is approved, then it goes to the Central MOEF in Shillong, and then it is finally approved, Your Lordship, and then implemented.
Learned counsel appearing for the respondent state has informed that amongst 32 forest divisions, in 10 forest divisions, working plan has already been approved and implemented. However, in relation to the other forest, remaining forest divisions, the process is going on. And after seeking necessary approval, the plan will be implemented. We place some time to inform this court regarding the approval and implementation of the plan in respect of the 22 forest divisions where the work is under progress. Just after 6 weeks.
Deeply, deeply.
26.
In this matter, Your Lordship, the issue was regarding the presence of formaldehyde in fish which is used for general consumption by the public. What had happened, Your Lordship, was a similar matter with an identical issue was also taken up by the Honorable NGT, Your Lordship. The NGT has disposed of that matter in view of the SOP which is prepared by the Government of Assam. I have the order here with me, perhaps Your Lordship may have.
In relation to this very,
One of the issues was this very issue.
Lordship, I am not aware about the NGT order, but on the last occasion, I had sought time before this honorable court to peruse the affidavit and seek instructions, which was filed on 16th of February 2024. As per the affidavit I had received on 16th of February 2024, it says that the SOP drafted by the state government has been implemented with effect from 20th of January 2024. But my lord, the SOP which has been implemented, in my humble submission, Lordship, there are some shortcomings which I can show before this honorable court on the basis of record and on the basis of the affidavits filed by the respondents. If your Lordship kindly has page number 77, my lord, running page number 77.
where is the mention of this SOP in this NGT order?
Yes, Lordship will find otherwise the issue which is because for the NGT, Your Lordship will find at paragraph number 3. And regarding the SOP, Your Lordship will find it at paragraph number 13 onwards, the final conclusion. In fact, paragraph number 16, the direction itself is online.
Yes. Where is the mention about this SOP?
Yes, at paragraph number 16, Your Lord.
15.
16, the direction itself is that we accordingly dispose of the present original application with the direction to the state respondents to strictly conform to the standard operating procedure SOP in the matter of prevention of menace of use of formaldehyde for the preservation of fish in the state of Assam.
Is it a matter which comes within the purview of NGT? Use of formalin in the fishes?
Yes, perhaps.
An environment?
Yes.
Green issue.
Actually, the issue in this particular case is health. It's the consumption of the imported fish, because of which we have approached this honorable court. And it is not an issue relating to the environment. It relates basically to the food safety and the health of the citizens of the state.
And apart from those, perhaps those 4 acts which are specifically under the purview of the NGT, which are in the but this SOP is on record in this proceeding also.
It is, my lord,
Yes.
but just there are some lacuna, my lord.
NGT.
Lucy. Lucy.
Sir, we have a length of that is supported. That will come in the future.
The color page number 135.
Relationship of water air and मछली पकड़ के ये बीच साइड ट्रांसपोर्ट कर ये जो अंदर में मछली पकड़ ये मछली को भीतर काटने का ठीक है गाड़ी में डाल के जाने
What are the shortcomings in the SOP?
Lordship, the SOP basically provides that the state will appoint nodal officers in each district and they will conduct a random test as to whether the fish contains formaldehyde or not. My lord, this same procedure was also followed in the month of May, June 2023. Now, if I may take your lordships to page number 77 of the file, my lord.
इनको बोलते हैं कानून क्या random test are since becoming
77.
the data executive
Who is appearing for the state here?
Lordship, I am appearing on behalf of the additional advocate general.
Okay, now that there is a SOP, which was notified on 20th of January 2024. You file an affidavit giving us the result of the tests conducted so far in respect to Kamrup Metropolitan District, and what are the findings?
In respect of Kamrup.
Yes, this nodal officers.
After this implementation of this SOP, what steps you have taken and what are the findings?
Very good.
One humble prayer in this, with regard to Kamrup Metro, let the nodal officers also conduct a test, and for the same period, the State Public Health Laboratory or the Guwahati University may also be directed to conduct.
Provide the details as per the SOP, if they have conducted any this random survey or whatever the rate.
I have an objection to that, my lord. Reason being page 77, it will show all the contradictions, my lord. All the contradictions. What had happened, my lord, during the period from April to May 2023, the College of Fisheries, Roha, had conducted a test according to the direction of the state government. State Public Health Laboratory had conducted. Guwahati University also conducted. Dibrugarh University also conducted. And the fishery departmental officers at district level also conducted. Now, my lord, when we talk about the College of Fisheries, Roha, Assam, or Guwahati University, or the Nagaon College, in all these three universities or in all these three institutes, formaldehyde was present according to the report. Whereas, my lord, the fishery departmental officers had also conducted tests, and it does not mention of which district. So it is assumed that it had conducted tests in those districts as well.
26 numbers of district, all samples
Found negative, my lord.
negative.
That is the contradiction. When the institutes are carrying out a test, they are finding cadmium and arsenic also in the fish. They are finding formaldehyde in the fish also. But as soon as it comes to the random testing being carried out by the nodal officers or the fishery departmental officers, all the samples are being shown as negative. Now, there cannot be two contradictory findings. It is a scientific issue.
Negative मतलब नहीं है. All पे भी हो सकता है. All पे भी हो सकता है. Managed view. नहीं, इसलिए तो fishery department को जहाँ किया वहाँ पे पता नहीं किया होगा मानते हैं. तो ठीक है.
My humble submission, the entire authenticity of the test being carried out by the nodal officers is questionable, my lord. And the SOP provides only for the nodal officers to conduct the test, not any other institute or independent.
Who is the nodal officer?
The nodal officers are being appointed by the state government. And my lord, the latest.
But just a minute, that is of May and June 2023.
My lord, again, there was an updated report.
After that, after this SOP is implemented in January 2024, what we are asking them, can till date, how they have implemented the SOP and what is the result of that?
My lord,
That is the earlier part when
Agreed, my
SOP
lord.
was not there.
Well, not only the April-May part. After the filing of the instant PIL, formalin test kits were distributed in certain districts, not in all districts, which has been admitted by them in the affidavit stating that we directed the concerned fishery department officer to order formalin kits locally and purchase. So on the basis of that, for the period of September, October also, the state respondents have provided us with the findings.
What we are saying that certainly your concerns are genuine in relation to the year 2023, but after this SOP is implemented,
This SOP
there is
was
whether this is SOP is effective or not, for that purpose we are asking them to furnish a report.
my lord, that is why in addition to that, my only humble submission is along with the nodal officer, let an independent agency also conduct the same inquiry.
Let them file. Ultimately, if we are not satisfied, then certainly we'll
Because we will
order
not
for
get to
that.
know whether it's correct or not. If they say it's negative, we don't know whether it's.
Let them detail out what steps they have taken pursuant to the SOP and whether those steps are effective or not. We'll consider it.
My lord.
Let them file a
Where is the SOP?
My lord, it is at page number 102, my lord.
137, Your Lordship. The notified SOP,
137.
136.
It's not there. 137 is not there. Perhaps it is in.
137 in the latest affidavit dated 16 February 2024.
137.
137.
137.
152.
It is dated
20 January
20th of
2024.
January 2024.
150, 152. 152. They're not giving the correct.
Yes. Notification standard operating procedure for restricting import stock so and so. Here, in concept of the respondent, state has submitted that while notification dated 20th of January 2024, the government of Assam Fishery Department has published a standard operating procedure SOP for restricting import slash stock slash sale of fish imported other than self-sufficient states by road slash river route using formaldehyde, keeping fish in marketable condition for long duration. It is submitted that the SOP is implemented from 20th of January 2024. Learned counsel appearing for the petitioner has submitted that there are various shortcomings in the SOP and has also pointed out that there is a variation in respect of the inspections carried out by the State Health Public Laboratory, College Fisheries, Assam, Guwahati University, Nagaon College, Dibrugarh University, and the Fishery Departmental Officer at district level in the year 2023. Learned counsel for the petitioner has submitted that though the other agencies has found chemical formaldehyde in the
Formaldehyde.
formaldehyde in the fishes fishes imported from the other states. The fishery department in its survey has found all the samples negative. Full stop. It is contended that looking to this contradiction, it is necessary to get a report from an independent agency other than the state agency. Full stop. Having heard the learned counsel for the parties and after taking into consideration the fact that the SOP is implemented from 20th of January 2024, we deem it appropriate to direct the counsel for the state to furnish and affidavit in respect of the Kamrup district, affidavit of the nodal officer in respect of the Kamrup
Affidavit of the action taken pursuant to poem and
affidavit of the chief executive officer detailing out the action taken by it pursuant to the SOP dated 20th of January 2024. The said SOP, the said affidavit be filed within a period of 10 days, 2 weeks, 3 weeks from today, list on
also indicating the outcome of the test carried out by the nodal recorder. Section filed within 3 weeks, also indicating the results of the tests conducted by the nodal agencies designated under the SOP dated 21/2024 by furnishing relevant facts and figures. The affidavit be shown by the Commissioner and Secretary of the Fisheries Department, Assam.
Waiting for respondent number. They are appearing in the respondent number 4. You are for the respondent. Who is the respondent number 4?
Because of. Let them find it.
Started now. Let them find their response, then yes, consider it. 3 weeks, but whatever the date, this point. 10th of May. 10th of May.
Lordship, if it could kindly be considered, my lord, if it could be on 13th of May, my lord.
Why?
Lord, I will be out of station, my lord.
You have already prepared the program in advance. 10th of May is so far.
Fixed matter, my lord.
13th of May.
Deeply obliged.
You serve advance copy to both sides.
Item 28.
Payment has already been made to the petitioner, Your Lordship.
What happened to the bill?
It's paid, Your Lordship.
Paid?
Yes, Your Lordship,
that was-
kindly peruse the documents. I've furnished.
39 lakhs,
Yes, sir.
46,000,
Yes,
all money.
yes, Your Lordship.
It can be closed, madam. It may be closed, madam.
Like,
Although I have no information, but and I that is given record, madam.
It has,
Can be closed, madam.
it was, Your Lordship, would kindly come to the last page, Your Lordship.
yes,
That is 31st of March 2024.
yes.
So the process has been completed, Your Lordship. The matter may be closed.
Then consider, the standing, MSN Bordoloi, then standing council revenue and disaster management department of Assam has furnished certain documents stating that the amount of rupees 39,46,179 has already been paid to the appellant. Stop. And the counsel for the appellant is not in position to disclose the said fact. In such circumstances, said fact, the documents produced by MSN Bordoloi are taken on record. Full stop. Taking into consideration that the pending bill of the appellant has already been cleared. No further order is required to be passed in this writ appeal. The same is therefore disposed of.
Deeply obliged, Your Lordship.
31.
Record.
Yes, Your Lordship. This application is filed. Although they have challenged the survey, but thing is that, my lord, the point is that the law point is involved is that I filed the petition before the DRT. DRT has rejected on one ground, it is barred by limitation. It is not covered, they are limited, DRT has no power to condone my delay. That is the point to be decided. Because there are so many judgments given by various courts in the Supreme Court, but this court has not given a state guideline whether the Section 5 Limitation Act will apply or not. That is a problem, and he is delayed on 2 judgments, my lord. In short, I am telling, my lord. There are so many points in the surface which has not been considered.
Lordship, may I submit?
There are two more.
Contradictory order, self. Explain. Explain. Not that the
Now, my last, what do you want to say? Even I cannot. Just nothing.
Lordship, Section 17 of the SURFACE Act, after being amended on 2016, is the original jurisdiction of the Learned Debts Recovery Tribunal. It has been held. If it is an original jurisdiction, Lordship, the question of condonation of delay does not arise. It is akin to Section 19 of the Recovery of Debts and Bankruptcy Act. Lordship, Section 19, if your Lordship takes into consideration Section 19 of the Recovery of Debts and Bankruptcy Act, together with Section 17, both are the original jurisdiction of the Learned Debts Recovery Tribunal. Now, if it is an original jurisdiction, Lordship, the mandatory provision is under Section 17 is to file the application within the period of 45 days. Now, Lordship, if we go back to the Mardia Chemicals case that my Lord is well aware of, in that case, it was held that application before the Learned Debts Recovery Tribunal is akin to a civil suit. If Lordship, it is akin to a civil suit, in place of the civil suit, because when a person is aggrieved by the decision taken by the bank, instead of going to the civil suit, he approaches the Debts Recovery Tribunal. And that is the original jurisdiction of the Debts Recovery Tribunal. If that is so, Lordship, I'll take your Lordships to first to the decision of this Honorable Court, of our Honorable High Court, decided on the same matter. Now, Lordship, for a moment, an appeal lies to the DRAT under Section 18 of that, if a person is aggrieved by this decision taken by under Section 17. In this particular case, Lordship, in this case also, the Learned Debts Recovery Tribunal rejected the SURFACE application on the ground that it was barred by limitation. An application under Section 2, Article 226 was filed before this Honorable Court. This Honorable Court held that since the remedy lies under Section 18 by way of appeal, they should have.
That's right. Means the DRT order, they have a remedy to file an appeal. That's before the tribunal. That's right.
Yes. Now, Lordship, so for the original jurisdiction of this Honorable of the DRT is concerned, that has been decided by the Honorable Calcutta High Court as well as by the.
Just a minute, Mr. Mitra, is there any decision of the Supreme Court
Yes.
on these points, Section 17?
Yes, I'm
Where is that decision? Please show it. Appellate remedy is not a remedy here.
Yes.
The question is whether the delay in approaching the tribunal
Yes.
beyond 45 days is at all condonable or not.
No,
The
this
appellate
is-
tribunal also
this is
cannot
Supreme Court
condone it.
decision, Lord. I'm showing you.
Yes, my lord. This question is still open. Your lordship, I can give you that copy, my lord. Still open. By the Supreme Court, my lord, that it has not yet been decided.
No, no.
This is just-
The tribunal in its order specifically said that the Supreme Court has clearly held that section 17.
No, it is
Yes,
wrong.
lordship.
It is wrong. It is wrong. Totally wrong, my lord.
No.
It's a but misinterpreted by by the Land Council of there, my lord. It's not there.
This is in Bank of Baroda case.
In Madria Chemical, my lord, this is Madria Chemical, my learned friend is.
Just
In Bank of Baroda versus Paracetamol, this one.
Yes, yes.
I'm just taking your lordships to pay.
this must apply to the dispensation provided in section 17 of being similarly worded.
Yes, my lord.
But what happened in that? It's still pending.
It is still pending. So this question is still pending and still open, not yet decided.
And which is that judgment the Honorable Supreme Court has said.
Lordship.
If it is decided that it's decided.
Paragraph 6.
Just.
Paragraph 6. Bank of Baroda.
2022. 11th of August.
Bank of Baroda.
Para number.
Paragraph 6.
The present proceedings commence with the challenge to award of sales certificate and acquisition. Is important.
Then paragraph 7. Lordship. And even lordship.
Just
Why you are so hurried?
No, I'm not in hurry. Perhaps you are in hurry.
So if your lordship can point out, in this case, my lord.
Let us.
Yep. Here's another decision of the
Issue before the Honorable Supreme Court is the passing remark, not that.
Yes, my lord. This is a ratio not maybe laid down. It's the omitted dicta.
This is another decision, lordship, of the Honorable Supreme Court.
Rely on a decision wherein they specifically said that can't be condoned.
Lordship.
That's all.
I'm reading paragraph 14.
14.
Yes. The RDB Act, Recovery of Debts and Bankruptcy Act, is a special law. The proceedings are before a statutory tribunal. The scheme of the Act manifestly provides the legislature has provided for application of limitation to the original proceedings before the tribunal under section 19 of the 19 only. The appellate tribunal has been conferred with the power to condone the delay beyond 45 days, not the original jurisdiction, under section 23. The proceedings before the recovery officer are not before the tribunal. Section 24. Now what, my lord? Section 24 of the RDBA Act provides. Section 24 is limited to in its application before the tribunal before the originating in under section, the exclusion of any proceedings for extension of time by the tribunal is preferring an appeal under section 30 of the Act makes it manifest that the legislature intent exclusion was expressed. The application under section 5 by resort to section 29(2) therefore does not arise the prescribed period of 30 days in preferring the appeal against this one. So far appeal is concerned, Lordship, the condonation of delay is here. What I mean to submit, Lordship, if it is an original jurisdiction, it is akin to the suit. Now, Lordship, if the condonation of delay is allowed, in every application, the person otherwise, the intention of the legislature would have been specific.
There must be some judgment. Both of them is not. That's right, but now this question is becoming power head. Oh yeah, this is vulnerable to power. Hmm. We have problem there. This is the first judgment. That's to be either other way, either it's not going to be sections. Limitation is so big that bank professor can't. There's no power to everything. In that case, this decision becomes complicated. এখন কি জানেন হ্যাঁ কোনটা দিয়েছি কি না কোন যে বলে सारे में जगह
international assets. International assets.
तो ये Facebook पे जो
Arguing out. You are arguing out. Argue the matter.
Lordship,
At any date and you have filed your counter from the.
Yes, Lordship.
You have already filed. Where is that counter?
No, I'll be filing my contract because I've not filed it.
Supposed to file.
It's a point to be decided, my lord. This is a point. It is a point actually. There, since the Supreme Court is not given clear guidelines, so different High Court has given different guidelines. If you also give you one judgment, if you also go through this, you will clear understand by this is why the
Which is that I got, that's why only we want to.
Yes,
hear
yes.
you, na?
Yes, my lord. He is relying only on Calcutta High Court judgment.
No.
That Calcutta is bad in law. It is decided by
Sure.
Even Kerala High Court also given the same judgment.
Kerala High Court judgment is against that this KL George judgment.
No.
Is still pending.
Look, Calcutta High Court is bad in law because some superior court has declared or you have declared.
No, this is on the record. I've given just now. I've given.
No, you just said Calcutta High Court judgment is bad.
You
Why
let
is
him
it?
know
Because you don't like it? Or is there a decision by a superior court that is?
No, not superior court, but it is reflected by this judgment, my lord. Just now I've given Porras Laboratory.
Then we have to express a view, taking into consideration the different views of the different high courts.
Yes,
We
my
have
lord.
to take a view.
No, that is not held bad in law. What my
That may be, bad in law, even we can't declare it as bad in law. That is only.
No,
let
I
the
just
Supreme Court
read
to say,
that
we
paragraph.
may agree or we may not agree.
Agree, yeah.
But we can't declare it as a bad in law. Yes. The question to be decided in this writ petition is whether the debt recovery tribunal constituted under the Securitization Act, so and so SARFAESI Act, clothed with the power to condone the delay in filing the application under section 17 in case the said application is filed after expiry of 45 days, the time limit prescribed under section 17. Stop. Learned counsel for the parties. Learned counsel for the appellant. Petitioner has submitted that the various high courts has ruled that the debt recovery tribunal is having power to condone the delay. Counsel for the respondent has submitted that some of the high courts have already taken this view that the debt recovery tribunal has no power to condone the delay. Full stop. The concept of the respondent is directed to file counter to the writ petition. Within a period of
3 weeks.
3 weeks. Stay is operating against you.
Stays there, madam.
That's why only they are asking.
That is why lordship, a date may be fixed.
Then concept of the respondent seeks 3 weeks time to file. Count to the writ petition time for the granted. Just after 3 weeks, in the meantime, the interim order passed by this court on 11/12/2023 shall remain in currency. Shall remain in currency till next date.
A date may be fixed. Lord.
We are communicating.
Mr. Nandi, be wary of one fact. If this court holds that there is no power to condone the delay, that would also amount that the writ petition is maintainable. Because he cannot be left remediless. So if you succeed on that point, you will have to face the
Argue the matter on
you have
merit.
to argue the matter on merit and justify your action.
Item 32.
May I please, your lordship, my lord, this instant appeal has been preferred against the judgment and order dated 6/2/2024, my lord, which has been passed ex parte against the appellant, my lord. The judgment starts at page 75, my lord.
Ex parte, you are,
I was added as respondent number five in the writ petition, my lord. And the notice of the writ petition was never served upon the petitioner, my lord.
this, Mr. So and so, no one appeared on, though the order dated 412 were passed by this court state that the service of notice upon the respondent deemed to be complete.
Yes, my lord. Now, if your lordship,
Order is there already.
if your lordship come to the order dated 4/12/2023 at page 23, my lord.
23,
Yes, my lord, page 23.
yes.
My lord, the operative portion at page 24, my lord. This is the order dated 4/12/2023, and before that, my lord, if your lordship,
24, yes.
before that, my,
Private single steps or directed to taken registered as justice or registered is concerned, neither AD card received nor received back. So far as justice affidavit has been filed stating that the notice was standard, the same was refused to be accepted. This is a relevant office note in this regard. Accordingly, so it is deemed to be complete.
yes, my lord. Before that, my lord, the order of the Lojima Court at page 21, my lord. Page 21, my lord. It says that, my lord, page 21, my lord.
Yes.
The fourth paragraph, now in regard to the notice issued by registered post with AD, it appears that neither the AD card nor the answered notice has been received back. And the track consignment report available with the case record shows that the status of the notice as item received by Lalpur Bazar SO as on 16/8/2023. So the petitioner is a resident under the post office Gerua Bazar, my lord, not Lalpur Bazar. So AD card, the registered post with AD card, that shows that it was delivered to the Lalpur Bazar. So registered post notice was not served upon the petitioner. And
Next para,
next para, the dusty service, my lord.
further in regard.
Further in regard to the notice issued through dusty mode, it appears that the petitioner has filed an affidavit regarding service of dusty notice under response number 5. In the said affidavit, it has been stated that on 3/8/2023, the deponent along with one Chandan Doimari, he is the chairman of Dolgaon Gaon Panchayat Samabay Committee Limited, went the residence of the respondent number 5 to serve the copy. But the respondent number 5 to serve the copy, but the respondent number 5 refused to accept the same. My lord, this dusty service notice has never been served upon the petitioner. If your lordship kindly come to the dusty service affidavit at page 69, my lord. That particular notice at page 72, my lord. So in this notice, one person has just put you 72, my lord.
Yes.
So it was addressed to the appellant, my lord, respondent number 5 in the writ petition. But it has never been served upon the petitioner by appellant, my lord. As a matter of fact, my lord, the writ petitioner never went to the writ appellant, my lord. And one difficult.
Whatever
अंतिम में तो दस्ती नोटिस एंड एप्लीकेशन तो आपको Is it? Really no. But I I don't know. They were and you want to give the family. But custody decision finally case actually I get that was name of person. You recognize both. Especially वो वही नहीं करता है तो that's all यहाँ कंटेंट में तो ये तो होता नहीं है ये तो प्रेफर करेंगे
your application, there you have not accepted the notice, and here this respondent number 5 has not accepted the notice.
Yes, my lord. And I have.
But he refused to, again, your DP Boral issued the respondent was offered to him, but he refused to accept the same. In this regard, 3 witnesses have affirmed the same, and we have believed on that. So if the learned single judge is believing the affidavit of that, your affidavit, we are believing your affidavit. What is this business?
Or your
This
lordship
justice
may,
service,
or your lordship may direct for, because in addition to the dusty service, we have taken the registered post with AD also, my lord. That steps also we have taken, my lord.
But that has not been served.
Yes, my lord. So either we can, the service report, we can wait for the service report, or we may be directed to take fresh steps or whatever your lordship thinks fit.
That's why only because this fishery is up to 30th of June.
Yes, my lord. And
That's why only we
otherwise,
are buying time. If
otherwise
30th of
also, my lord,
June nikal jayega, then
no,
we'll do that.
my lord, on merit also, my lord, the petitioner is not eligible, my lord. The official respondent have also filed affidavit, my lord. Otherwise also, my lord, the petitioner is not eligible, my lord.
Though this court might order dated 13/3/2024, taking note of the affidavit filed on behalf of the appellant, as treated the service of notice upon the respondent number 5 as complete. But we feel that the notice upon the respondent number 5 is not properly served, and therefore the petitioner, the appellant is directed to take steps for issuing fresh notice to the respondent number 5 through registered AD only, not by Basti.
Yes, my lord.
Basti business is very fishy.
Yes, my lord. Obliged, my lord. My lord, interim order passed earlier, so maybe continue.
That is the main, we wanted nothing else. Interim order passed by this court shall continue till next date.
Obliged, my lord.
33.
Lordship, this IA has been filed, Lordship, for adding the respondent number 4 and 5 and 6 to a party because the college has now been upgraded to a university, Lordship.
Yeah, yeah.
IA 901.
Here, the matter comes upon for consideration of the IA number so and so with the prayer to impede the impede Ravindranath Tagore University Vice Chancellor Ravindranath Tagore University and the Registrar Ravindranath Tagore University as respondent number 4, 5, and 6 in the connected appeal number
138.
138/2019.
19.
Full stop. Yes, Mr.
Lordship, we have no objection.
Taking into consideration the amendments made in the IA number so and so, the same is allowed. The Rabindranath Tagore University and the Vice Chancellor and the Registrar of the said university are ordered to be implemented as respondent number 4 and 4, 5, and 6. IA is disposed of.
I have to submit a press cost title, Lordship.
Number so and so in appeal number so and so. IA is disposed of amended cost title be filed in the appeal number so and so within a period of 1 week.
So notice have to go to the newly implemented.
It will be listed. That amended constitution.
Oblige.
34,
That is lost. This case, my lord, for a moment, lordship, kindly have a look in order dated 17/10/2023, lordship.
17th.
17/10/2023. माफ करो sir.
What happened? That judgment still not pronounced.
My lord, it is, so far my knowledge is concerned, it is not overruled. Lord. Recently, so in, on 1st of December, February 2024, the Honorable Supreme Court has decided that case, my lord, having, my lord, considered that judgment lordship, that paragraph 16 kindly see lordship. My lord,
Sir, inform the larger bench of the Supreme Court has delivered its judgment.
my lord, I could not, my lord, find out that, my lord.
Then what is
Recently.
this?
My lord, this is, my lord, in on, my lord, 1st of February of 2024 lordship.
Yes.
The Honorable Supreme Court has, my lord, have a note that the that judgment is not overruled yet, lordship, and the stand taken in that the K. case is still exists, and that was applied in this case, paragraph 16 kindly see, lordship.
Coordinate bench in Himani Malhotra is the larger bench express a view which is different from that taken in K. Majusi and referred the matter of the chief tribunal in the larger bench. There is no decision yet from the larger bench.
Yes, Lord.
So you mean to say that larger bench has not delivered its verdict?
My lord, so far my knowledge is not, it is not clear, Lord.
Then it's okay.
Now, as per this paragraph, lordship, that came on this case, my lord, is still hold the field, lordship. And that was applied in this case, lordship. In a reference made by now my lord Jharkhand High Court, lordship.
Okay, then we have to wait for that larger bench decision.
Lordship, as per the my lord paragraph 16 of this judgment, my lord, lordship can decide, my lord, on the basis of my lord judgment of K. Justice case, my lord. That is not yet overruled, my lord. It is clearly stated in this judgment, paragraph 16. May I read, lordship? The same view has, lordship. The same view has later been taken by a coordinate bench of this court in the case of Himani Malhotra versus so and so. In a later decision, as Prakash Pathak and others versus Rajasthan High Court and so, a three-judge bench of this court expressed a view which is different from that taken in case of K. Manjushri and referred the matter to the Honorable the Chief Justice to.
K. Manjushri, the learned single judge has clearly held that yes.
Yes.
That is
Now, next paragraph,
Manjushri, but however, the candidates who have secured lowest mark, this prepared pursuant to the selection held in terms of the admission being not before this court, no any relief can be granted. This is the main ground for denying you the.
My lord, in my case, it is there, my lord. It is the ground, my lord. My lord, in my case, my lord, the learned single judge, my lord, has my held that I was deprived from selection, my lord, by playing the rule of gum sensing rule lordship. And my lord, relief was not only lordship, relief was given.
But the persons
yes,
who were appointed or who were lower in merit than you were appointed were not party before the court.
Lordship, not party. Now, immediately thereafter, my lord, I filed a my lord, review petition, lordship. Review petition, my lord, saying that the post is still vacant, my lord. 10 numbers of post is still vacant. My lord,
But there is already an order awaiting the.
We'll await for the verdict of the larger bench, sir. Again, it may create many complications. We are not. Okay. This court, by the order dated 17/10/2023, has already deferred hearing of this writ appeal awaiting outcome of the larger bench decision. Which is going to consider the ratio of the judgment K. Manjushri versus State of Andhra and another reported in 2008 3 SCC 5/2. List after 6 weeks. Let's wait for that.
Well, may I pay for a date, Lordship, my lord, I am suffering since 2010.
Sure, you suggest a date that the larger bench decision or verdict will come on so and so date. Immediately thereafter. Which is that date?
My lord, date is not given the, by the
6
whole
weeks.
Supreme Court, Lordship.
We are not certain, then we can't fix it.
All right, Lordship.
6 weeks.
Item 35.
And it's a Somoto, TIL is a very tragic incident, my lord. A mother committed suicide after killing her two children, my lord. And then, my lord, this honorable court registered a case, my lord, and asked the deputy commissioner to make an inquiry and to submit report. And they have filed a affidavit and they make an inquiry.
Autonomous Council has filed affidavit.
Council has filed.
You filed affidavit. Dated
1/3/2024. I received on 1/3. 1/3, no? 1.
Yeah. It's awesome. This Autonomous Council come in the 6th schedule.
Yes.
Yes. Yes. So there are various. $95 or $95 question.
मिला है नहीं.
There are 4.
So the council has taken a decision to conduct a survey.
Yes,
You are appearing for the council? Yes. Yes, we are asking. You have taken a decision for conducting a survey of each MSC constituency for identifying economically backward families and thereafter to provide support to those families. Where is
Right.
that order of conducting survey and what is the mode of survey? What is that?
Right.
I require some time, I'll produce it.
What do you mean by required some time? When you have already filed this affidavit, you should have filed along with it. What measures you are taking for that? If the people are not coming, seeking help for the various schemes you have launched, then what is the action plan of yours? How you are going to educate the people? That these are the program which we are running. You can take benefit of it. Where is the action plan?
Madam, that action plan, I will produce it before Your Honor, on the next, any day.
Very vague affidavit. Okay. The affidavit filed on behalf of the missing autonomous council. It is mentioned that the council has taken a decision to conduct a survey in each MSC constituency for identifying economically backward families and thereafter to provide support to those families. Stop. The full stop. Any such decision, the copy of the said decision is not produced along with the affidavit in opposition. Then it concept to the MSC missing autonomous concept is directed to file further additional affidavit placing on record the copy of the decision of the MAC to conduct a survey and also to detail out that if when such survey is conducted, when such latest survey is conducted and how the missing autonomous council has provided relief to the economically backward families. List after 4 weeks.
Yep,
Fine
yep.
and acceptable.
Item number 36.
May it please your lordship. My lord, the appellants are the shareholders who wanted to participate in the election. They were debarred from being held that.
You were supposed to file certain additional documents.
My lord, I have filed it with the additional affidavit on 14/3/24.
14/3/24.
My lord, and I have
Those
stated
documents.
with documents of the RTI saying that in 16, 17, 18 and 19, my lord, their AGMs were not held because of non-fulfillment of the Quran, but we attended those AGMs.
When the AGMs were not allowed, you attended those AGMs.
But we attended the meetings, but the AGM could not be held because of the lack of quorum. As per section 34, the quorum was not there. At least 10% was there, but in different, in the 2016, 17, 18, 19, some of the appellants participated in the election. Sorry, the AGM. I have stated in paragraph 5, 6, 7, and 8, my lord. And I have annexed those documents. Page 122, your lordship will find it.
Mr. Rajchandran. See, the issue as we understand is you are aggrieved by the notification which mandates that those who want to contest the election for board of directors must have attended at least 2 AGMs in the last 5 years.
My lord.
Correct?
My lord.
Now, your clients have failed to meet this requirement, as a result of which They were debarred from contesting the election.
As the authority told us that you will not be allowed to participate because you have not.
Now, did you submit nomination?
My lord, we could not because they refused us. Then we approached this court. Learned single judge held against the statutory direction. We cannot pass in mandamus. We approached the division bench. Division bench held. Let the election be held, and result will not be declared. Only 14 persons who were holding the post earlier, they were selected in the election. There was no election. Those 14 persons, they were 15.
But those 14 persons had attended at least 2 AGMs in
My
the
lord,
last 5 years.
as they said by the respondents official.
No, please.
You are disputing that or not?
My lord,
You are disputing this fact or not?
my lord, they have also participated. We have also participated in the AGM.
Those 14 persons have complied with the condition of attending.
Yes, my lord, they have complied and we have also complied.
How you have complied?
Because well, from annexure 122 page, we have.
Then why have you challenged it?
Because my lord, they have refused us to participate in the election. They didn't allow us to file the nominations.
What was the date of filing nomination?
My lord, 24/1/24 was the notice. And my lord, election was to be held on 8/2/24. My lord, in the writ appeal, my lord.
The date of submission of the nomination was 29/1/2024.
And when was the writ petition filed?
Writ petition was filed on my lord. February, my lord. My lord, the order was, it was. The learned single judge passed the order on my lord 5/2/24. On 25/1/24, we made a representation to the authority, to the executive officer, that allow us to participate. When he kept it pending, no discussion was there on the representation. We approached this court, current single judge held that against the statutory direction, we cannot pass an order of mandamus. Only 14%.
That's not it. According to him, he also. What do you have to say on this? He says the persons who contested the elections, they had attended, that he is agreeing. But he's saying he also attended, his clients also attended those elections.
No, my lord,
What do you
your
have to say on
lordship
that?
Exactly, your lordship has, my lord, rightly, my lord, asked the question whether they have tendered the nomination. In fact, my lord, if your lordship comes to page 34 of the notice, my lord, it says, my lord, they did not tender.
Answer the question. What my lords have asked.
Yes.
Your case is that those 14 persons have attended 2 AGMs in the last 5 years.
My lord.
And they are not attended.
My lord.
He is claiming that he has also attended. What is your response to his claim?
My lord, in fact, nobody, my lord, restrained them from submitting, my lord, the nomination papers. They did not submit the nomination paper, rather they came to the honorable court. This is, my lord, not borne out of records. That is why I am trying to point out to your lordships, my lord, at page 34.
So
the date of nomination was 20.
Case is that nobody has restrained them from filing
Absolutely not, my lord. The date was 27th for submission of nomination. Before, my lord, the completion of the date from 27 to 29, my lord, the date of submission of nomination paper. Before that, my lord, they submitted on 25 one application saying that let us permit to participate in the election. Nobody restrained them, my lord. On 25th, if your lordship comes to page 35, on 25th, my lord, they have
your
filed.
cases, they are not disqualified.
My lord, my respectful submission is.
Then in that case, your case is that these persons are not qualified, were not disqualified, and they themselves have not filed their nomination papers.
Exactly, my lord. They are now trying to, my lord, take advantage of their own wrong, my lord.
Oh, but
My lord, I have another, I have another submission, my lord. Since, my lord, this is an election process. Now, whether, my lord, my humble submission is, whether they can tinker with, my lord, an election process, my lord, when they do not submit the nomination papers,
concern
whether
your,
this honorable
your
court.
argument that they have not filed their nomination paper can only be considered in case you are admitting that these persons were not disqualified.
Exactly, my lord, that is what I'm trying to say. Had they submitted the nomination papers, their nomination would have been considered. It has not been rejected because they did not even submit it, my lord. My lord, they tried to preempt, my lord, the election process.
Just a minute.
My lord.
ये कह रहे ये लोग गए ही नहीं नहीं इन्होंने एप्लीकेशन ये एप्लीकेशन कोई कंसिडर नहीं किया कॉम्बिनेशन देने के बाद रेट रिफ्यूज करते so it will be in case of improper rejection that would have a yeah, we're saying the condition instead of submitting the nomination they challenge that condition in 24(1) to come. इसमें लिखा है कि at least 2 out of the 5 it's given
We are refused to file the petition for the next issue, my lord.
but won't come back. Why would they challenge that law?
You have moved an application on 25th.
25th.
Where is that application?
Page 35. In the writ appeal, my lord.
Most state that the AGM was fixed on due to COVID-19 was not held for last 3 years. Therefore, executive officer Suleiman Sadiq Rahan Vice order dated allowed all the share contested due to defective voter list of AGM was cancelled. It is notified that AGM will be held on itna, but it is sad to say that in the notice the mandatory attend last 2 AGMs for previous 5 years. Otherwise, no shareholder participate in the election. Sir, it is the same election. And it is a conspiracy for this section shareholder to pay the therefore it is really great that you are not pleased to report the order. You are allowed to participate in the AGM election and withdraw the condition mentioned in the notice and pray for allowing all to participate in the AGM election.
In elected matters, if there is no order at any time, if you should only determine general, you fulfill, you don't fulfill it. Now, they have to either say that they will qualify or they qualify. He has 22 and the ground that he doesn't qualify. Now he says he qualifies. Keeping
is this. That's another. He's saying they never completed the. Roy Chaudhary, now you are claiming that you have also attended two AGMs.
My lord, that, yes,
That
sorry.
you, all these petitioners have also attended those two AGMs and you were very much qualified to contest the election. This is your case now.
My lord, my case is, there is little bit of bifurcation of that, my lord. Previously, the AGM was to, election was to be held in 2024. So they have said for last 5 years. So for 5 years, we thought it from 1819 onwards. Because 1920 onwards, there was one-man committee. So now they came up with a affidavit saying it should be from 2016. When they said it was from 2016, we went for an RTI. From RTI, now in a RTI, we have come to know that in 2016 onwards, we have participated in the AGM. They have come with an affidavit saying that it is from 2016 will count.
Where is that? Where is that? The condition of attending to.
My lord, that is at page. Vernacular is at page 31. And it starts at page 30. And my lord, translation copy is at page 28. And relevant is at page 29.
Read base 29.
As per section 42 of the Cooperative Societies Act.
No, this is, I think so, this 29, just.
29. Read a bit.
Yes, 29.
As per section 42, my lord, your lordship.
Yes, as per.
As per section 42 Cooperative Societies Act, the candidate who desires to contest the election for the post of board of directors, he has to attend at least 2 annual general meetings in the previous 5 years, and his signature must be in the attendance register of AGF. Previous 5 years, there was no specification whether it was from 16 or 20 or 24. If it's to be held in 2024.
Page 29, yeah.
So you approached this court under apprehension and then this 5 years starts from preceding 5 years from the date of issuance of notice.
My lord.
And what is their stand before the?
They came with an affidavit saying it should be from 2016 because thereafter from 2020 there was a one-man committee. So it's from this 2016. Then we applied for an RTI where we found that from 16 onwards, AGMs were not held because of non-fulfillment of quorum, but we have participated in this AGM.
So what is the ground to set aside the election now?
My lord, there was no election held. Only 15 posts.
Right, so you should have submitted your nomination.
My lord, because of that particular 42, we are not been allowed to participate, my lord.
So where is that denial?
My lord,
Where is
denial.
the refusal on the part of the respondents?
My lord, denial because of that clause, we are not been allowed. Only your lordship will find.
Where is the refusal that you?
My lord, refusal, your lordship will find at page 32, final list of valid candidates. Only 14, those who have, my lord.
Valid candidates, you have not even filed the nomination, then certainly these are the valid candidates.
These are the
who have
persons who are holding the post. They are in connivance with the respondent, my lord, officials. They are the person holding the post, previously elected.
Mr. Roy Chaudhary, you realized the mistake. You may argue whatever you want. Your client should have filed their nominations.
My lord, because we are debarred from, my lord, because of that clause.
Where is the order of debarring you, sir?
Because that 42, my lord, previous 5 years, that 40 clause 2.
At 2, you prepare with that refusal.
My lord, refusal as well, my lord, there is. May it please, my lord, the issue before the learned single judge was against the clause that was incorporated in the notice dated 24/1/24, where it has said that because of section 40 subsection 2, you are prohibited from participating in the election because previous 5 years, there was no year mentioned.
No. It's Mr. Roy Chaudhary, please argue in the correct perspective. It is not you are prohibited. It's those who have not
Yes,
taken part in
I
at
will
least
argue on that,
two,
my lord.
because that is the requirement of statute.
My lord, that is what I have.
If your clients have not participated, then they will not be allowed to contest the
My
election.
lord, that is what I am
Yes.
placing before lord.
Hmm.
So 24/1/24, last 5 years, they said previous 5 years you have to attend the AGM. That is why, otherwise you will not be, it is automatically we are prohibited under the law. We are not apprehending, we are prohibited under the law to
No,
participate.
Mr. Roy Chaudhary, see, other aspects we can consider.
My lord.
But if you have not submitted your nomination, you cannot claim any right regarding the election.
My lord,
You
your
can
lordship.
argue on that.
My lord, that is what I am placing before lord. My lord, 24/1/24, last 5 years from 19 onwards, there was a COVID pandemic, then one-man committee, there was no AGM held. So we automatically, we place a representation before the executive officer. Last 5 years, there was no AGM. We are prohibited under the law. So please allow us to participate.
He cannot allow you. There is no such provision. On the
138,
date of election, on the nomination, when the nomination filing opens, you have to go and simply file your nomination.
that way, my lord, they are
If they
also in the
don't
last
accept
5
it,
years.
then it could be a ground of improper acceptance or rejection of nomination.
That is my lord. They have not participated. In the previous 5 years, those 14% has also not participated because there was no AGM held at all. Now they come with a stance that it is from 2016. We have made a specific statement in para 10 of my writ petition that when you went to get the nomination paper, they said you will not be allowed to participate because last 5 years there was no AGM and you have not participated in the AGM. There is no denial as such. Now the case they have brought before this honorable court that it should be from 2016. So when from 2016 we are eligible. My lord, that clause is 24/1/24 previous 5 years. Previous 5 years is from 2019. There was no AGM. They also have not participated. We have not participated. Where from it comes from 2016, my lord? 16, my lord, there is no whisper as regards the notification that even after the representation we have filed in 25/1/20.
No, but are these issues the subject matter of challenge in this proceeding?
Well, before the writ court. Before the writ court.
Then the writ court will decide the matter now.
My lord, that is what, my lord, your lordship may remand the matter to the writ court, my lord. Let not the result be declared.
The red court remand, where is the question?
Oh, not remand, my lord, sorry. My lord, the writ appeal, either your lordship, my lord, allow this writ appeal to that extent of let the interim order continue till the decision of the writ petition. Otherwise, my lord, it becomes infructuous.
No, you should have submitted your nomination.
My lord, because their paragraph 10, my lord, they have not denied as such that you are, I have been refused. Paragraph 10, my lord, I have categorically stated in my writ petition. Paragraph 10, page, my lord. Page to the. In my writ petition, my lord, paragraph 10. It is at page 47. My lord, the petitioner approached the respondent number 6 and 7 for collecting nomination paper, but they were refused to provide nomination paper by showing the reason they were not attended the earlier AGM. There is no denial as such, my lord, to this particular statement. Now first of all, their case is this, it should start from 2016. Now, when we have stated that 2016, we also participate, they have now come to a case, they have brought a case that you have not filed a nomination. In my representation and in that clause itself does not show which 5 years. Last 5 years, they have not participated, we have not participated. How could they become eligible, my lord? 2024, 24/1/24, 5 years is from 2019. Page 32, my lord, that clause is there. In the previous 5 years, his signature must be attendance register of AGM. Previous 5 years. No date, no year mentioned, my lord. I have specifically made a statement, my lord. In that affidavit, no denial as such. And we have not attended the AGM, it is true, my lord. In the same paragraph we have stated. Because there was no AGM held. They could not also participate in that AGM, my lord. The notice itself is, we have challenged that notice, my lord. Notice itself is bad, without disclosure of the particular previous 5 years.
Hello, the relevant part of the notice not having been translated. Hello, 2 lines, my lord, I'll read from the notice at page 31. It's in vernacular for your lordships, my lord. Page 31, the first para of the notice, my lord. 4 lines from bottom. It starts as, my lord, if your lordship has got page 31, man.
Yes.
It reads as, my lord, Oha 27/1/24 ইংৰাজী তাৰিখে ৰাতিপুৱা 10 বজাত কাৰ্যালয়ৰ সমিতিৰ কাৰ্যালয়ৰ সম্পাদকৰ পৰা আবেলি 4 বজালৈ আৰু 29/1/2024 ইংৰাজী তাৰিখত মনোনয়ন পত্ৰ জমা দিয়াৰ শেষ সময়লৈকে মনোনয়ন পত্ৰ ল'ব পাৰিব। মনোনয়ন পত্ৰ প্ৰপত্ৰ মাচুল 10 টকা দিব লাগিব। So on payment of ₹10, any shareholder can obtain, my lord, the nomination paper. Nowhere they have stated that.
So is there a statement in the writ petition?
The writ petition, there is a statement, my lord.
Where is it? Which?
Para 10, my lord. Page 47.
My lord, the nomination paper will be supplied by the secretary and it can be collected from 27 to 29. Before collecting, they have, my lord, submitted an application on 25th itself. They knew, my lord, that it will be, my lord, refused to them.
They could have replied to that, my
will
lord.
see, my lord, all this, my lord, sequence of events.
My lord, they have not
And
replied to that, my lord.
Let me complete. And there is no statement on the writ petition that the secretary, even after payment of 10 rupees, my lord, had refused to pay, my lord, submit or supply the nomination paper.
It is there, my lord. The petitioner approached, but they were refused to provide nomination paper.
The secretary will supply, my lord.
Respondent number
payment of
6 and
rupees
7.
10.
There is no denial as such, my lord, to that.
My lord, for your kind consideration, lordship, from the office of the secretary, lordship, out of all other appellant, 2 appellant has collected the nomination paper. I have the records, lordship, I have been furnished from my client, lordship. I am unable to file the affidavit in opposition because there was a direction from this honorable court after allowing the impleadment IA, which I have filed, to the appellant for submitting a amendment for the cost title, which was not done by the appellant. That is why I am unable to file the affidavit in opposition. Otherwise, the record says that out of all the appellant, 2 appellant has collected 3 nomination paper.
So they are allowed?
They have not submitted.
They
have not submitted.
They are taking, my lord, trying to take advantage of their own wrong. They did not, on one hand, they did not, my lord, submit the nomination paper and they can directly come to the court, my lord.
Another aspect, my lord, very important issue. Rule 12 of 2019 election rule. It says that, my lord, a nomination paper shall accompany a receipt of non-refundable nomination fee as showing below issued by the society. For the purpose of the present society, it should be 5,000 rupees by way of a bank demand draft, my lord, which they have not submitted.
You're reading which?
Rule 114 page.
Rule 12, page number 114. Rule 12, page number 114. Page number 114.
Election rules 2019.
114 page.
Assam Cooperative Society Election Rule 2019. Rule 12 and Rule 13.
This condition in the notice
No.
dated 21/24/124 is incorporated
My lord.
as per section 41C, 42 of the Assam Cooperative Act
Right.
2007.
My
Whether
lord.
you have challenged the validity of this provision.
My lord, in my writ petition, I have challenged this notification, notice.
Notice, what about this section 40?
Section 40, my lord, because there were orders from we have annexed in the writ petition, orders from the other coordinate benches because of 130A, because it was incorporated in
So that is altogether different. 138 relaxation can be provided.
relaxation.
Here in this case, if the relaxation is not provided, now you are seeking that this condition be waived, means this operation of section 40 be stayed.
My
That can't be done, sir.
my lord,
While entertaining the writ petition, how the operation of the law can be stayed? The learned single judge has rightly declined to interfere, grant any stay order.
My lord, if,
consider it.
my lord, I understand your lordship, my lord. Only if your lordship allows me to read 130A, my lord.
Yes, 138.
Exemption in certain provision by general and special order. The state government in exceptional circumstances like pandemic may by general or special order exempt any registered cooperative society or class of registered societies from the operation or provision of section 39 and section 41(2) of the of this act.
Have you applied before the state government for the this,
My lord.
relaxation and this provision?
We filed a representation before the executive officer,
Who is the executive officer? The state government is the
who was,
authority.
but he was the authority to hold the election.
Whatever it may be, sir, how can whether he has power to exempt this,
My lord,
grant this relaxation?
my lord, because the word
The
is state government.
is only, you should have applied to the state governments. That, you don't find anything, sir. This is.
Otherwise, my lord, if you had not been prohibited, we would not have to approach the honorable court, my lord.
The
No, it may be.
petition is still pending.
Writ petition is.
It is still pending. The learned single judge will decide this. They're not in fact. Now to continue the interim stay order, what it may be.
Otherwise, my lord, your lordship will fix a particular day to dispose of, because we have challenged the notification.
We'll request the learned
Learned
single
single
judge to decide at the decide its petition.
My
Nothing else.
only case now, as it exists today, after your lordship has said, that, my lord, whether the notice, the word previous 5 years would count from 2016,
That is for the learned single judge to decide, sir,
my lord.
not
That,
for us.
that is the only,
That is the
only
case.
cause of action that survived.
This intra-court appeal is filed by the appellants being agreed with the order dated 5/2/2024 passed by the learned single judge in WPC number 5/4/2024, whereby by issuing notices to the respondent of the aforesaid petition, the learned single judge is refused to grant any, pass any interim order to allow the petitioner, appellants to contest the election for the post of directors of the, which is that the society?
My lord, Madhu Solmari Samabay Samiti Limited
So
of Dhubri district.
In the AGM fixed on.
in the AGM fixed on 8/2/2024. Full stop. The learned single judge has observed that it is not the case of the appellants that they have fulfilled the condition of attending at least 2 general AGMs of the society in the previous 5 years. it is contended that it is observed by the learned single judge that taking into consideration the said fact, in the event the prayer of the petitioner in the form of interim relief is granted to contest the election of the board of directors of the society, despite the restriction under subsection 2 of section 40 of Cooperative Societies Act, which is the name of the Assam Cooperative Societies Act 2007, would amount to an order in violation of the statutory prescription contained therein. The learned single judge of the was of the view that no mandamus lies for issuing direction to act contrary to a statutory provision, and such direction may result in destruction of rule of law. Full stop. Having heard the learned counsel for the appellant as well as the counsel for the respondent, we don't find any illegality in the impugned order passed by the learned single judge, as it is settled that no mandamus can be issued in violation of the statutory provisions. Full stop. In such circumstances, we don't find any don't find any case for interference. The writ appeal is dismissed. However, taking into consideration the issue involved in the writ petition, we deem it appropriate. We request the learned single judge to decide the writ petition expeditiously.
My lord, one more prayer. There is an interim order operating for not, my lord, declaring the result. That may be vacated.
The interim order passed by this court, while order dated
7/2/2024.
7/2/2024 is hereby vacated.
Deeply approved.
Passed over item 20.
May I please the lordships? My lord, we have challenged here two orders. One is the order of learned single judge, that is page 13. And another order passed by the authority, that is page 38. As can lordship can see page 13. Here, my lord, there is a circular.
Yes.
There is a circular that a person who has not attained the age of 65 years, he is entitled to be nominated as the president of high school. There is SDMC, president of SDMC. There are some other conditions also. Those are not in dispute. Now, 65 years is the criteria fixed.
5 years the term.
Yes. Now, lordship can only come page 38. Man.
Yes.
Page 38. An instruction of the Honorable Minister, TM number so-and-so, is received from the Additional Deputy Commissioner Education, Borpeta Hyde number so-and-so, dated so-and-so, on an allegation, and accordingly the documents in respect of the President of School Management and Development Committee, SMDC of Shevrachora MK Higher Secondary School, namely Amjad Hussain, is verified and found that Amjad Hussain has crossed 66 years of age, and which is not covered the government guidelines as president of the SMDC of the school. Under the above circumstances, the president of the SMDC of so-and-so school, namely Amjad Hussain, is hereby removed from the president of SMDC of the said school with immediate effect. Now, my lord, my submission is this. First thing, my lord, this order has been passed in violation of principle of national justice.
no notice was served upon me. Secondly, my lord, it is apparent from the record that he was influenced by the education minister. He himself was not perhaps so much interested.
A president of the SDMC can be continued up to what age?
My lord, elementary education 3 years, but the guideline, lordship, guideline is
Upper age limit.
upper age limit 65 years.
65.
So when I was selected, I was 64 years.
You were selected in which year?
My lord, first I was selected on 4/10/2021. That is,
At that time you were 61 years old.
so at that time,
64 years.
64 years.
Okay.
Now, lordship,
Even though if you would have selected in the year 2021,
yes,
you can continue up to, you were eligible to continue up to what age?
no, but that was the, yes.
Answer the question.
If that, if I was 21, that it would be up to 66 years, that would be in the 2027.
Why?
2026 will be.
How can it be?
21, 5 years.
You were 64 years of age in the year 2021.
Yes.
A president can continue up to 65 years.
Up to 65 years is not there, madam.
Huh?
Up to 65 years is not there. That is vague, lordship. Kindly,
That is not there.
yes, kindly see page 35. I invite lordship page 35.
That's 45.
Guideline.
Where is 27/6/2016 circular?
Page 31, kindly see, page 31.
31.
Yes.
Yes.
Page 31, kindly see condition number 1, president and vice president of the SMDC should not be more than 65 years of age. So it is when, my lord, when this 65 years shall be counted. It is vague, my lord.
Definitely cannot be appointed. Very loosely. That's the problem. What is the term in office?
That, my lord, in elementary it is 3 years and I think it is 5 years, my lord.
Where is that?
That is not here in the circular, nor in education manual.
Which is that circular?
There is one circular, my lord, that
So what is the total, what is the period of the STMC once it is constituted? Duration.
tenure of SMDC is 5 years, my lord.
Where is that?
That is circular, my lord. That circular, my lord. I'm not, but here our view was that, my lord. And lordship would say that this is the guideline.
The day when you were appointed as the president of the STMC.
I was recommended first.
Yeah, because
Thereafter, that was executed in the year 2023.
whatever it may be, when you were appointed, actually appointed, you were you have already crossed the age of 65 years.
Yes, that is true. But thing is this, my lord.
Yes.
No, here shall not be more than 65 years. But here, or on the day of selection, or the last, as you see, this is not clear. This is not clear.
That would be deemed that no president after attaining the age of 65 years can continue.
That may be an interpretation, but it is silent, my lord.
That is the interpretation.
Then
You just, what is the duration of this SDMC?
then lordship, my lord, I have then lordship may kindly fix another day. I will. It is. I remember.
Place for and granted time to place on record the guidelines whereby the duration of the SDMC, what is the full name of this?
President.
SMDC.
SMDC, what is the
Of my lord Shaurasara, higher secondary.
Management and Development Committee.
Development and Management Committee.
History,
School
yes.
Management and Development Committee. Okay. Can is fixed.
President, Vice President.
Duration of the president or the vice president of the SDMC.
That may kindly be fixed, my lord.
Any date, whatever you want,
Next week after 24, any day, my lord.
any date after 24th.
After 24.
Lordship, I have a small request to make. In the morning, item number 11, 11 and 12 was taken up. There was an interim in that matter, 11 and 12.
11 and
Due
12.
to mistake, we were unable to extend the
We
interim.
have already, I think so.
I pray your lord, I seek your lordship's apology and pray that the same may be extended.
But order sheets have already been signed, sir. 14th May. Order sheets have already. Move an appropriate application, will extend this. Okay.